My business went under. I'm being audited about the business income, and I have to go for an interview with an IRS agent. I don't know what to say. I know if I lie, I can go to jail, but do they really do that? I'm not sure. Is there any way to get out of an interview? And if not, what should I tell them?
The IRS has the ability to not only to summons bank records, but they can actually summons an individual to show up. And if that individual doesn't show up, the case gets referred over to the U.S. Attorney's Office, and then that taxpayer who didn't show up for the summons at the IRS has to show up in front of a federal court judge and explain why. It's called an order to show cause, and explain why they didn't show up for the IRS interview. So yes, the answer is yes. The IRS can force you to show up and ask you questions. The only time that you can reasonably not answer the IRS questions is if you invoke the Fifth Amendment privilege of the right against self-incrimination. And if that's the case and you do that, the IRS is going to refer your case over to the Criminal Investigation Division, and you will have a criminal investigation on your matter. So my advice is do not ignore a summons, show up to a summons, and be sure to cooperate with the IRS.
Now, that's a case where you can take an IRS problem and turn it into a criminal problem without realizing that's what you're doing. And what we come up with again and again and again is you're 100% of the time better off to deal head-on with an IRS problem and get it resolved one way or another. And you may not owe nearly as much money as you think.
Yeah, that's absolutely true. And in this case, we have a taxpayer who has a corporation, and the corporation may owe more tax. And if this corporation no longer exists and that tax gets assessed against the corporation, it doesn't get paid by anybody anyway. So it's kind of a non-event. I had a case that was almost identical to this one, to this scenario. It was very unusual. I had a very ornery taxpayer, a very aggressive individual, and he had a corporation that no longer existed. But a couple years after he closed the corporation, the IRS audited the corporation and asserted $500,000 of tax due. The last thing I wanted to do was put my client in front of an IRS auditor, but I had to. I couldn't say, well, there was no reason to have a Fifth Amendment privilege. I just didn't want my ornery taxpayer in front of the IRS, insulting the IRS. Well, we showed up to the IRS audit, and the taxpayer did insult the IRS auditor, which I expected. So that audit ended, and then we took the case up to the appeals level, where we were able to knock out the tax, the assertion of the $500,000. We dragged it down to zero. However, even if we didn't drag that liability down to zero, and the appeals officer didn't agree with our position on the corporate income tax, given the fact that the corporation no longer existed, the IRS has nobody to collect from. The IRS can't collect from the individuals who own corporations for corporate income tax liabilities unless they assert alter ego or some theory of alter ego where the taxpayer was acting as though he was the corporation and vice versa. He was using the corporation as though it was his own personal bank account, and this taxpayer didn't do that. So I found it a little bit bewildering that the auditor pursued this case so aggressively, and then we had to appeal it. We eventually won the case, but even if we didn't win the case, the taxpayer wasn't going to be liable for the tax anyway.
Maybe it's because the auditor didn't like being called names by the taxpayer. That's never a good approach to take with the IRS. You know, Sam, let's get into a corporation can go bankrupt and the tax liability goes away. Partnership can't, limited liability. That gets so technical, so go ahead and talk lawyer on that.
Okay, well, a corporation in the eyes of the law is a separate legal entity. It can own property. It has its own social security number, which is called an employer identification number. It can enter into contracts and do business dealings. It can have employees, just like many corporations do, especially many large ones that we all know about, like large oil companies and energy companies. So corporations are separate legal entities. A partnership, on the other hand, is a conglomerate of individuals. Let's say it's a general partnership to make this example easy. A general partnership is a conglomerate of individuals who are all personally liable for the business entity's obligations, whether they be assets or obligations. So as far as business structures go, partnerships really aren't very well favored because they don't provide the general partners any type of protection against failure of the business. But a corporation that fails doesn't necessarily mean that the corporate debts become the responsibility of the individuals who own the corporation. There's a layer of protection there. And that's why people like to be in a corporate structure like a C Corp or an S Corp, which is like the equivalent of a small corporation where there's less than 32 shareholders, or an LLC even. Partnerships, general partnerships, are generally not favored and haven't been widely used in quite some time, actually.
Now, Sam, on this partnership deal, I think we discussed at one time that if you've got 2 or 3 partners and the company owes a tax liability, everybody owes all of that liability?
Yeah, it's not a partnership is not a corporation. So a partnership is a business entity or business organization where there's general and several liability among all the general partners. So if there is, let's say, $100,000 of tax due for the partnership, all the partners are responsible for the $100,000. If the IRS collects that $100,000 from just one of the partners, that one partner can then sue the other 2 partners for indemnification and try and receive their portion of contribution against that $100,000 debt back. So partnerships can be pretty messy. They're tough for accounting purposes. I prefer not to see them. There's some cases where they're beneficial, but generally we like to see people in C Corps, S Corps, or LLC.